कुछ कहना है बॉस?
बोला तो सर इतने अच्छे लग रहा है.
I'm just here to say sorry.
India's Supreme Court just told comedians like Samay Raina and Ranveer Alabadia to publicly apologize for their jokes about persons with disabilities. The Supreme Court called out influencers, saying they profit from harmful speech, which leads us to ask the question, what are the rules for social media content in India? Are there rules at all? The Supreme Court has said that these creators were commercializing speech. That means using social media content, that is jokes, posts, videos, to earn money. The court even suggested new guidelines should be made for influencers. But here's the thing, there are no clear rules for digital content creators in India. At most, the platform can take down a post if it violates the user rules. So what is commercial speech then? In legal terms, commercial speech is content made to promote a product or service or just to make money. In India, commercial speech is protected under Free Speech, Article 19, but only to a point. Once it becomes harmful, misleading or defamatory, that protection weakens. And if you post harmful content, the law might catch up with you. Through an FIR, IT rules strike, defamation case, or if you're in an industry, the regulations of that sector. Freedom of speech is not a free pass to profit of harm, but influencers are in a legal grey zone. TV anchors, newspaper editors, filmmakers, advertisers all have accountability structures and industry regulations. But influencers, they are not part of any company. They are individuals, and right now they are not covered by any formal content regulation. TV or media is regulated, films need CBFC certification, ads have ASCI rules. Influencers are unregulated territory. Attempts have been made, like SEBI rules for finfluencers, that is financial influencers, but these are sporadic and difficult to implement. In 2020, YouTuber Bearded Chokra faced a defamation case for a video about parachute coconut oil. He had to cut parts of the video, but the High Court did not lay down any rules for influencer speech. Why? Because the law treats them as individuals and not public broadcasters or advertisers. In 2024, the government proposed applying broadcast codes to social media creators. They wanted platforms to set up internal content review committees, but that blew up fast. Why? Because creators are not employees, and forcing them to follow industry-level rules could violate the constitutional right to free speech. The IT Act and rules allow social media platforms to take down or block content if it violates user guidelines, or there is a government intervention after viral outrage and complaints, like what happened in the comedian's case. And even then, the Supreme Court itself has said repeatedly that individual freedom of speech cannot be barred except in very specific circumstances. So where does that leave us? We have explosive growth in influencer content, zero formal guidelines, and legal action only when things blow up. In short, it's a legal grey zone where creators are both powerful and mostly unaccountable. So can influencers be held to the same standards as media houses? Or would that kill free speech online? It's an open question, one that needs very careful handling, because bans, penalties and regulations create fear and could block free speech.